All right, good afternoon, everyone. The time is now 2 p.m., and we're going to go ahead and get started. This is the State Expedited Accusations calendar in the State Court of Fulton County. I'm Judge Melanie Williams, and today is March the 2nd of 2023. All defendants, is courtroom 2 on the screen? I see courtroom 2. Yes. All right, all defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney at this proceeding. Our participants, this is being recorded and broadcast over the internet. That means any member of the public can watch this. Each defendant, when I ask if you understand your rights, that's what I'm referring to. Ms. Bridgewater, what is my reset date?
March the 16th.
Okay, I had a lot of feedback there for a second.
Oh. I can't hear you. Judge, I can't hear you.
All right, can everyone hear me now?
Yes.
Okay, I don't know what happened. That was quite strange. Anyone who receives a surety or cash bond will be reset to the state all-purpose calendar on March the 16th. Those who receive a signature bond will be reset further notice. All right. Let's see. Who do we have first?
Position 7, Ms. Kidd.
All right, Ms. Kidd, your case is 23 CR 001196Y. In this case, you're charged with simple battery family violence with the offense date of March the 1st. Do you understand your rights today?
Yes.
All right, as this is her first arrest, we'll go straight to Ms. Lewis.
Good afternoon, Your Honor. This incident occurred yesterday at 3004 Piedmont Road Northeast. Officer spoke with Elvin Kidd, who is Ms. Kidd's husband. He stated that Ms. Kidd threw her cell phone at him and hit him in the face several times while they were both inside a moving vehicle on 3004 Piedmont Road. We were able to speak with Mr. Kidd this morning. He stated he is in fear of his wife, as this is not the first time she's been violent with him. This is just the first time police have been involved. He also told us that he's in the process of filing a TPO against her. Your Honor, for this reason, the state is recommending a $4,000 surety bond to stay away from their residence, which is 7590 Bear Creek Trail in Fairburn. No alcohol, drugs, or weapons, no further contact, and 1-day anger awareness. I believe the victim is on the line. We'd like to sound for him at the appropriate time, Your Honor.
All right, I'll sound for him now. Mr. Kidd, if you're present on the Zoom conference and wish to make a statement, this is your opportunity to do so. I don't need to place you under oath. Are you present, Mr. Kidd?
I am present. Are you able to hear me?
I am. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
I do.
All right, thank you. You can put your hand down. I'm going to hear from you, but what I'm most concerned with is whether you wish to have contact with Ms. Kidd.
Okay, until the matter is resolved, I do not, but I have concerns for the children, and that was one of the things I wanted to be able to mention.
All right, go ahead, very briefly.
If you would consider allowing her to get out on her own signature, just so that she can care for her daughter, who has special needs, that would be the only thing that I ask that you consider.
Okay. I appreciate you coming to court and making a statement, okay?
Yes, ma'am.
All right, Mr. Finling, I'm assuming that this is your client. Please proceed.
This is my client, and good afternoon, Judge. Hope you've been well. I am representing Miss Kidd. She is 34 years old. She is employed. I believe, as we heard, this is her first arrest, and she does have family in the area, so she does have community ties. I would ask for a signature bond on Miss Kidd's behalf, Judge, and also a third party transfer, I guess, if need be, with the child. But due to her lack of criminal record, having zero criminal record, I am asking for a signature bond on her behalf, Judge.
All right. Ms. Kidd will receive a $4,000 signature bond through pretrial per judge. She is to complete the 1-day anger awareness course. Sorry, she's to have no contact with alleged victim, last name Kidd, and she must stay away from the shared residence on Bear Creek Trail. She can return one time with a member of law enforcement to get any items that she may need to possess, and she can arrange for the transport of children through a third party. Is there anything further from either the state or the defense?
Nothing from the state, Your Honor.
Nothing further. Thank you, Judge.
All right, Ms. Kidd, that concludes your hearing today. Best of luck to you both. All right, who do we have next?
Position 2, Ms. Claude.
All right, Ms. Claude, your case is 23 CR 001187D. In this case, you're charged with battery and theft by taking with the offense date of January the 22nd. Do you understand you're right?
Yes.
All right, thank you. This is her first arrest, but we'll go to Ms. Lewis as well.
Yes, Your Honor. So this incident occurred on January 22nd at 6125 Roswell Road, which is the Morgan Apartments in Sandy Springs. Officers responded to a harassment call and met Miss Amber Rhodes at this location. Rhodes stated that her and Claude used to be friends, and they're not friends anymore, and Claude has been harassing her for about a year now. On the date of this incident, Claude used profanity towards Miss Rhodes while she was in the lobby with a client. Rhodes then went through the gym to go to a restaurant next door and saw Claude, which prompted her to start recording so she could get evidence regarding her harassment claim. Claude saw Rhodes filming her and took Rhodes' phone away from her and started hitting her in the face with the phone and possibly a gym weight, as officers did observe several knots on Miss Rhodes' face. Rhodes stated that Claude never returned her phone and also took her AirPods. Officers were able to locate Rhodes' cell phone near a sewer drain nearby. Your Honor, we were able to speak with Ms. Rhodes today. As stated, they were friends, not anymore. They do live in the same apartment complex. And she stated that she's tried not to have any contact with her, but the defendant has consistently harassed her. And reason why she was filming is because she's trying to build for that harassment suit for her. The victim stated that the defendant saw her in the leasing office and went into a rage, which is when the attack began. For that reason, the state is recommending a $4,000 surety bond. That's $3,000 on count 1, $1,000 on count 2, to stay away pending her name not being on the lease of that apartment, no further contact, and no alcohol, drugs, or weapons. I do believe Ms. Rhodes is on the line, so we'd like to sound for her at the appropriate time.
Ms. Lewis, clarify that point. You're saying that it's unclear who lives at the 6125 Roswell Road?
Yes, Your Honor. So I believe she lives with her brother at that apartment complex, but I'm not sure if her name is on the actual lease.
Okay, but if she's living there, well, okay, we can dig into that in a moment. All right, Ms. Rhodes, I'm going to hear from you at this time. I see you're present. Please raise your right hand before you begin to speak. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, yes, Your Honor.
All right, you can put your hand down. Again, if you just saw the last person I spoke with, I will hear you, from a limited statement from you. But what I'm most interested in is if you wish to have contact with Ms. Claude. What would you like to tell the court today?
Absolutely not. No contact whatsoever. I do not want her to ever contact me again. Before she attacked me, I was dealing with a number of harassing statements from her, yelling. I mean, just everything to its degree is just really threatening. So I do not wish to have contact with her. I do not want her to ever contact me again. I want her to stay away from me completely. The attack that she did is caused great harm. I've had to endure multiple injuries at the time, and then even after that, I'm still dealing with the emotional and the mental impact of her attack on me as well. Where honestly, we were friends, but her reason for attacking me is so minuscule. She attacked me because she blames me for her not having any friends anymore. We used to have mutual friends, and I've decided to end my friendship with her on a number of reasons and red flags that I was able to witness. And a couple of our friends didn't want to be friends with her, not because of me, but she blames me, but it's in reality of her aggression towards them and things that her actions on herself. And so that is what she blamed me for. And that's in no reason for her to go in a blind rage. And the way she attacked me was like an animal. Like I never want to see her. I never want contact with her again. I want her completely away from me in all realms, in all realms.
Okay. I appreciate you making that statement, Ms. Rhodes. I just want to clarify one point. I do not want you to give me your actual address, but are you alleged to live where this incident took place?
So I actually just moved because of this incident and because I felt so unsafe. And because she's already threatened to kill me before, when she was attacking me, she threatened to kill me and threatened even before then, and has sent me multiple emails and harassing statements. But that was my last straw. I had to move in order for me to feel safe, because the way she attacked me and the merciless way that she attacked me, and how she already had threatened me and already said that she would kill me, I had to get out of that. So I literally just moved into a new apartment this past Sunday.
All right.
So you don't live there. Okay.
So the Sunday before, I moved into a new apartment because I just could not. It was just being in that area. It's just very traumatic. Like even if I drive close to there, like my heart starts beating. I start getting palpitations because it was so dramatic for me.
Okay. I appreciate you making that statement, Ms. Rose. I think I have a clear picture, and friendships can be tough. So I appreciate you coming to court today.
Thank you.
All right, Mr. Finlay, I think I have a clear picture, but please present your client's case.
Sorry, Judge, I didn't hear you cut off for a second.
I don't know what every time I use the county laptop,
Oh, it's okay.
I get a lot of issues.
Oh,
Can you hear me now, Mr. Finlay?
I can hear you, Judge. I can hear you.
Okay, I was saying that I think I do understand what we need to do here, but please proceed and present your client.
Yes, Judge. Miss Claude is 35, and while I certainly do empathize with what I just heard, obviously today it's not about the facts of the case, but about the conditions. And Miss Claude understands that there is to be no contact, that there is going to be a stay away. But what I also do recognize is that there is zero criminal record that Miss Claude has. She currently got laid off. Money is an object, and she's going to be unable to bond herself out, Judge. So I am going to be asking for a signature bond for Miss Claude. And I made very clear to her, and I think she does crystal clear understand that she needs to stay away. There needs to be zero contact. And I believe that she will abide by those, Judge. So I am going to ask for a signature bond.
All right. Defendant is going to receive a $4,000 signature bond through pretrial per judge. 3,000 count one, 1,000 count two. She must take the anger awareness course, and she's to have absolutely no contact with Ms. Rose via social media, phone, text. Do not drive past her. If you see her in the street, Ms. Claude, you look in the other direction. Additionally, you are to have no alcohol, drugs, or weapons as a condition of this bond. Is there anything further from either the state or the defense as it pertains to this case?
No, Your Honor.
Nothing further, Judge. Thank you.
All right. Best of luck to you all.
Excuse me, is that through the jail or pre-trial?
Pre-trial so that she can complete the anger awareness course.
Yes, ma'am. Thank you.
Thank you. Best of luck to you both. All right, who do we have next?
Position 1, Mr. Caesar.
All right, Mr. Caesar, your case is 23 CR 001199E. In this case, you're charged with 2 counts of battery with the offense date of January the 8th of 2023. You understand your rights?
Yes.
All right, thank you. Mr. Howard, can I have his history?
Hold on. He got an open case in Fulton, suspended license, window tint, misdemeanor possession of marijuana, possession of a firearm by convicted felon or felony first offender, possession of a Schedule 1 controlled substance, possession of a knife or a firearm during the commission. That's 22 CP 211524.
All of those charges are attached to that one case?
Correct.
Okay.
He had a battery DV that was dismissed. That was from 2013. 2012, misdemeanor possession of marijuana and obstruction. I mean, that's pretty much it. Everything else is old.
Okay, thank you.
Hold on, hold
And right now,
on. Yeah, that's it.
All right.
Yes, Your Honor. This incident occurred on January 8th at 6120 Peachtree Road, Peachtree Dunwoody Road, excuse me, which is a Hilton Hotel. Officers responded to a sexual assault claim and met with Miss Elizabeth Starnes while she was still at Northside Hospital. Starnes stated that she and her on-again, off-again boyfriend were in an altercation during a visit to Atlanta. Starnes stated that while she was with the defendant at the hotel, the defendant pulled her hair, resulting in redness and marks consistent with her hair being pulled. Starnes also stated that the defendant threw her cell phone across the room, and when she attempted to retrieve it, the defendant grabbed it and hit her in the forehead, causing swelling. Your Honor, we were able to speak with this victim this morning, and we're very concerned with the nature of this case. The victim actually called the police saying that the defendant raped her, and she was in the hospital, and we actually have the rape kit. However, the DA did not accept the charges based on how the police wrote up the warrant. The victim is extremely afraid of this defendant. She stated that she was in fear of her life and didn't think she'd even make it out of the hotel room alive. She stated that the defendant, after the assault, grabbed her by the hair and was swinging her around the room. Excuse me. The defendant said this is not the first time that, the victim stated the defendant has been violent with her before. This is just the worst case. Your Honor, because of the nature of this crime, and our office is still investigating, the state is recommending a $20,000 surety bond. That's $10,000 on each count to stay away from any location where the victim resides, no further contact, and no alcohol, drugs, or weapons. Nothing further.
Okay. And I just have to ask, Ms. Lewis, you said that the DA declined to take it because of how the warrant was written. What in particular is in the warrant? And I did not look at the warrant prior to court that makes this case slightly different. Do you know?
There's one line in the warrant regarding the sexual allegation.
Okay.
And Your Honor, I did reach out to the DA's office to kind of follow up. Their issue with it is, other than the one sentence and other than the information the victim provided us, there is no mention in the warrant of any kind of sexual assault. We just received the report about 5 minutes ago. It is much more detailed as far as the sexual assault allegations. For that reason, we're going to be sending that report up to the DA's office for a re-review now that we have additional information, and reaching out to the investigator. I've already called him, was not able to get in contact with him to get the additional information on why or whether additional warrants are going to be taken out.
All right, thank you. I'm going to sound for, Ms. Starnes. I don't see her on here, but Ms. Starnes, if you are present, this is your opportunity to speak. All right, hearing and seeing none, Mr. Finley.
Yes, Judge. Mr. Cesar is 44 years old. He is currently unemployed, Judge, but he does full-time take care of his mom, who is very sick. He does have 6 kids that he does his best to try to support as well, Judge. And I do understand, and Mr. Cesar does understand the seriousness of these charges. And once again, he does understand the no further contact, the stay away, and will abide by those conditions. And I do feel confident in that. I am going to ask for a $1,000 signature bond on behalf of Mr. Cesar, Judge.
All right, at this time, defendant will receive an $8,000 surety bond. That's $4,000 on each count. He's to have absolutely no contact with Ms. Starnes and must stay away from wherever she resides and wherever she works. Additionally, he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
No, Your Honor.
Nothing further, Judge. Thank you.
All right, best of luck to you, Mr. Cesar. Who do we have next?
position 3, Mr. Cosby.
All right, Mr. Cosby, your case is 23 CR 001188F. In this case, you're charged with fair evasion and criminal trespass with the offense date of March the 1st. You understand your rights?
No.
All right, Mr. Howard, can you put that history onto the record, even though I'm aware?
let's see, 1, 2, this is, hold on. This is fourth arrest. He was arrested in July for robbery, misdemeanor possession of marijuana. That's open, 22 CP 210825. Has a hold out of the cab. He also has 2 arrests out of South Carolina, April of last year. Financial transaction card fraud. That was dismissed, but it was another charge. It says RSG value 2,000 or less. That was a conviction. In 2021, open container, non-student disturbing schools, and failed to obey traffic control device. That's it.
Those were the one charge together, the
2
school?
different.
Oh, those 2 different,
Hold
okay.
on. You talking about the open container?
The school one and whatever you said last, those were 2 interesting ones.
So failure to obey traffic control device, open container, and non-student disturbing schools. Yeah, that was 1 arrest.
Okay.
All right.
All right, that's interesting. All right. Ms. Lewis, please proceed.
Yes, Your Honor. So this incident occurred yesterday at the Ashby MARTA station located at 65 Joseph E. Lowry Boulevard Northwest. Officers observed Mr. Cosby go past the entryway without paying the $2.50 fare. And it's also to note that this defendant has a permanent ban from MARTA, which went into effect July 21st of 2022. Your Honor, the state is recommending a $3,000 signature bond through pretrial services. That's $500 on count 1 and $2,500 on count 2 to stay away from all MARTA property and no alcohol, drugs, or weapons. Nothing further.
All right, Mr. Finley, I'm assuming you don't object to the signature bond.
That'd be correct, Judge. I don't object to that.
I'm sorry, Ms. Lewis, you said that he has a ban, a permanent ban?
He has a permanent ban. Yes, ma'am.
Oh, okay. All right, understood. All right, at this time, Mr. Cosby, you're gonna receive a $3,000 signature bond, but I'm gonna send it through the jail. $500 for the fare evasion, $2,500 for the criminal trespass. Additionally, you are to comply with that MARTA ban. Do not go back to any MARTA locations. And you are to have no alcohol, drugs, or weapons as a condition. Do you understand? All right. I believe that concludes the case. Is there anything further?
Nothing further. Thank you.
Nothing further.
All right, best of luck to you, sir. Who do we have next?
Position 4, Mr. Frazier.
All right, Mr. Frazier, your case is 23 CR 001192C. In this case, you're charged with battery family violence and with the offense date of March the 1st of 2023. Do you understand your rights?
Yes, ma'am.
All right, can I have the history, please, Ms. Howard?
3rd arrest, 2014 suspended license, 2013 DUI.
Okay, thank you. Ms. Lewis?
Yes, Your Honor. So this incident occurred yesterday at 1750 Commerce Drive Northwest. Officers responded to this location and met with Dawon, that's spelled DAWON, McDowell, McDowell. McDowell stated that the defendant threw objects at him, which cut his elbows, and also punched him and pulled his hair as he tried to protect himself from the blows that were coming to his face. Your Honor, the state will be recommending a $3,000 surety bond to stay away from this location, no further contact with the victim, and no alcohol, drugs, or weapons. I'm not sure if Mr. McDowell is on the call today, but we'd like to sound from him at the appropriate time.
All right, Mr. McDowell, if you are present, this is your opportunity to speak. All right, hearing and seeing none, Mr. Finlay, please proceed.
Yes, Judge. Mr. Frazier is 31 years old. He does hold full-time employment at Verida Inc. He does have community ties as well, Judge, and did assure me that he would be coming to court in the future and would be compliant with receiving, keeping his address updated and so on. But I am gonna ask for a $1,000 surety bond on Mr. Frazier's behalf. He also assured me that he will abide by, obviously, any conditions that are set.
All right, at this time, defendant will receive a $1,000 surety bond. He is to have no contact with Mr. McDowell and stay away from that location on Commerce Drive. Additionally, he's to have no alcohol, drugs, or weapons as a condition of that surety bond. Is there anything further?
Nothing further, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Position 5, Mr. Furlow.
All right, good afternoon, Mr. Furlow. Your case is 23 CR 001191G. In this case, you're charged with improper lane change and a hit and run due to stop at the scene of an accident with the offense date of December the 13th. Do you understand your rights today?
Yes, ma'am.
All right, Mr. Howard, can I have the history, please?
This is fifth arrest. Last arrest was 04 and 2003 for suspended license. I think the one before that was 02 arrest.
That's sufficient. Ms. Lewis?
Yes, Your Honor. This incident occurred on December 13th at the intersection of Roxborough Road and Peachtree Road. Officers responded to an automobile accident near this intersection and spoke with Mr. Bradley Bostic. Bostic stated that Furlow came into his lane and sideswiped his vehicle. Bostic stated that Furlow did not stop after the accident. Officers were able to contact the defendant, who stated that he believed Bostic was actually at fault for the accident. But it is to note that the defendant did not report any accidents anytime thereafter. For this reason, the state is recommending a $1,500 surety bond. That's $500 for count 1, $1,000 for count 2, and no alcohol, drugs, or weapons. Nothing further, Your Honor.
All right, Mr. Finley?
Yes, Judge, Mr. Furlow is 47 years old. He is currently unemployed, but looking for a job, Judge. He works in maintenance primarily. He does have community ties. I also do have a good address for him as well, where he can receive mail, and did assure me he would definitely be at court in the future. He does have 4 kids as well, 3 boys and 1 girl. And once again, is from Atlanta. All of his family lives here. So this is where he will be. I am going to ask for a signature bond on Mr. Furlow's behalf, Judge, but if you're not inclined, a $1,000 surety bond.
All right, defendant will receive a $1,500 signature bond through the jail. 500 count 1, 1,000 count 2. Additionally, he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
No, Your Honor.
All right, best of luck to you, sir. What do we have next?
Position 6, Mr. Hill.
All right, Mr. Hill, good afternoon. Your case is 23 CR 001195Y. In this case, you're charged with 1 count of possession of marijuana less than an ounce, having an obscured or missing license plate, and possession and use of drug-related objects with the offense date of March the 1st. You understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have the history?
2018 simple battery conviction. 2017 sale of marijuana conviction. He got an open case in Superior Court, robbery, false imprisonment, and battery. 23 CP 216657. That's it.
Okay, thank you. Ms. Lewis?
Yes, Your Honor. So this incident occurred yesterday at 1450 Donnelly Avenue Southwest. Officers were patrolling this area when they noticed Mr. Hill's vehicle with a dark plate, and there was an obstruction of the view of his tag. Once the officers were able to get behind his vehicle, they ran the tag and discovered that the defendant was wanted out of Atlanta for the robbery charge Mr. Howard just mentioned. Officers stopped the defendant, and when they approached the vehicle and looked inside, they noticed 4.1 grams of raw marijuana in plain view, as well as a scale. Your Honor, the state is recommending a $1,500 surety bond. That'll be $500 for each count, and no alcohol, drugs, or weapons.
All right, Mr. Finley?
Yes, Mr. Hill is 26 years old. He does have employment as a DJ, performing for different artists, and on the side does work DoorDash as well. So he does work hard. He does hold 2 jobs. He does have community ties, Judge, and I do have a good address for him where he can receive mail. He does have 1 child that he takes care of as well. That's 3 years old. I would ask for Mr. Hill to have a signature bond, but if not inclined, Judge, then a $1,000 surety bond.
All right, defendant's gonna receive a $1,500 split bond. It'll be 500 surety on count 1, 500 signature through the jail on count 2, and 500 surety on count 3. For the total of the 1,500 split, he'll have to make bond on 1,000, and he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Your Honor, did you say signature bond through jail or pretrial? I'm sorry.
Through the jail for count 2.
Thank you.
All right, Mr. Hill, that concludes your case. Best of luck to you. All right, who do we have next?
Position 8, Mr. King.
All right. All right, good afternoon, Mr. King. Your case is 23 CR 001184Y. In this case, you're charged with DUI and improper lane or erratic lane change, each with the offense date of February the 28th. You understand your rights?
Yes.
Mr. Howard, can I have his history, please?
Got second arrest. He had a bench warrant for failure to maintain insurance. That's it.
All right. Ms. Duncan, please proceed.
Yes, Your Honor, this incident did occur on February 28th in the area of Georgia 400 northbound, like right before exit 7A. The defendant was driving a Hyundai Santa Fe, and he was observed by two independent witnesses, Miss Eileen Donaldson and Andrew Serene. They witnessed him driving on the highway at a high rate of speed. And he was driving behind them. He swerved around both of their vehicles and sideswiped the right concrete barrier, and then dashed across all lanes of traffic, hitting the concrete barrier on the far left side of Georgia 400 northbound. According to Mr. Serene, there were sparks that flew from the vehicle at the time of sideswiping the concrete. When officers arrived, the defendant had exited the vehicle but did not put any lights on, and by him exiting the vehicle without putting lights on his vehicle, it caused a second vehicular accident involving two other vehicles. When officers got to the scene, EMS was called and the defendant was speaking with EMS. While he was doing so, the officer could smell the odor of alcoholic beverage coming from the defendant's breath. As he spoke, officers also indicated that he had bloodshot, watery eyes and slurred speech. When officers spoke to the defendant and asked him if he had anything to drink, he did confirm to officers that he had some drinks. They asked if he would like to do field sobriety test, and he consented to field sobriety test, and he also stated at that time that he was impaired. Officers were able to complete HGN, but after completing the HGN, the defendant decided that he no longer wanted to do any other evaluations, but based on the officers' training and experience and the circumstances, they believed it was enough probable cause to place him under arrest for DUI less safe and the improper lane change. Given the facts and the nature of the offenses alleged, we have concern for the other motorists on the road and the defendant's safety. Drinking while impaired is very, very dangerous, especially given that he caused 2 accidents between 3 vehicles while doing so. For those reasons, the state is going to be requesting a $6,500 total surety, a $3,500 surety on the DUI, and a $3,000. I'm so sorry. It's $4,000. $3,500 surety on the DUI and $500 on the improper or erratic lane change, no alcohol, drugs, and weapons, no further violations of Georgia law, and no driving unless he's validly licensed and insured. We don't know if the officers are going to consider that a failure to consent, so his license may be suspended because of this DUI. Nothing further from the state.
All right, thank you. Mr. Finley?
Judge, Mr. King is 30 years old. As we heard, this is only his second arrest. He does work full-time at a company called In Community, and there he works for people with special needs and that need special assistance, such as bathing them, feeding them, and so on. And he does have community ties, does have a good address as well, that he will receive mail, so he'll certainly be at court in the future, Judge. I am going to ask for a signature bond on Mr. King's behalf, but if not inclined, Judge, then a $1,500 surety bond, the breakdown of 1,000 and then 500.
All right, defendant will receive a $3,000 surety bond. It is $2,500 on the DUI, $500 on the erratic lane change. He's to have no alcohol, drugs, or weapons, and he's not to drive unless he has a license issued by the Georgia DDS or other state licensing authority. Is there anything further?
Nothing further from the state.
Nothing further. Thank you, Judge.
All right, best of luck to you, Mr. King. Who do we have next?
Position 9, Mr. Lau, Germany.
All right, Mr. Lyle, Germany, your case is 23 CR 001185E. You're charged with battery family violence with the offense date of February the 28th. You understand your rights? All right, this is first arrest. We'll go to Ms. Duncan.
This incident also occurred on February 28th, 2023 at 7350 Campbellton Road Southwest, apartment 607. The victim in this case is Kia Maria Nicole Thrasher. That's Kia Maria, Kiamaria. Nicole, common spelling. Thrasher is Thrasher. In this incident, the victim and the defendant do live together. Based on the warrant, it's indicated that Ms. Thrasher was thrown out of the shared home by the defendant when he went through her phone and accused her of cheating. However, she left her, the warrant does indicate that there are two children involved. However, I don't know if they're children together. She stated that her daughter was still inside, so she tried to get back in, and a physical altercation ensued where the defendant in this case scratched the victim, leaving visible scratch marks on her neck, face, and arms, as indicated by officers. We're concerned that because these two parties are in a relationship, so there's some concern there for the state, and for those reasons, we understand that this is the defendant's first arrest. However, given the egregious nature of violence alleged and injuries witnessed by officers, we're going to be requesting a $3,500 surety. No further contact with the victim in this case. If they share any of those two children, we'd ask for a third party, and stay away from the incident location. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further.
Thank you. I'm going to sound for Ms. Thrasher at this time. Ms. Thrasher, if you're present and wish to make a statement, this is your opportunity to do so. All right, hearing and seeing none, Ms. Kim.
Yes, Mr. Lyle, Germany is 30 years old and he's from Pennsylvania. He has been here in Georgia for about 2 years. He resides with two children, 4 and 5 years old, and he does have a full custody of those children as a single father, Your Honor. He is gainfully employed at St. Ivy Country Club as a chef. He successfully graduated from high school, and they broke up. The kid's mother and my client completely broke up, and they do not live together. So my client has no objection to stay away nor no further contact, so as long as there's a third-party transfer for child visitation. We would like to request for a signature on bond, and yet if Your Honor is not inclined to give him a signature on bond, we would like to request for a maximum $1,000 good bond. Thank you.
All right, defendant will receive a $5,000 signature bond through pretrial per judge. He is to complete the 1-day anger awareness course and have no contact with the alleged victim, Ms. Thrasher. He must stay away from the incident location. He can return one time with law enforcement to get any items he might need to collect. He can arrange to transport his children by contacting and coordinating with a third party, and he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further state other than its objection to the signature in the battery family violence case.
All right, thank you. Duly
May I
noted.
please confirm the address of the stay away?
Oh, Ms. Duncan wants the stay away address?
The incident location as reported on the warrant is 7350 Campbellton Road Southwest, apartment 607.
That is my client's address, and which she does not reside there. So can we have a one-time law enforcement officer to verify that
Yeah.
she does not reside there, and then he can?
Yes, we'll convert that one-time escort to a one-time verification with
Sure.
law enforcement. If she's not there, he is free to return to that location. If she is there, he must collect any items and stay away from that location. Does that solve our challenge, Ms. Kim?
Yes, Your Honor.
All right. Best of luck to you, sir. And again, the state's objection is noted. That concludes your case. Who do we have next?
Position
Oh, and I apologize. Did I say 1-day anger awareness? He does need to take that. That's it.
Yes, you did.
All right, making sure. All right, who do we have next?
Position 10, Mr. Miller.
All right, Mr. Miller, good afternoon. Your case is 23 CR 001186C. In this case, you're charged with criminal trespass and giving false information with the offense date of March the 1st. Do you understand your rights? I'm assuming that nod was a yes. You understand? All right, perfect. Mr. Howard?
You got about 35 total. Hold on. Open case out of Jonesboro, possession of drug-related objects. On probation in Superior Court, 21 SC 177996. Theft by taking, battery, fleeing an officer, and obstruction. On probation in Douglas County for a CWAC charge. That should time out in 2031. Also on probation for riot in penal institution. Shoplifting, obstruction, giving false name. Also on probation in Fulton for ag assault, entering vehicle. Possession of a firearm during the commission.
That's good. I've got it. Thank you, Mr. Howard. Ms. Duncan?
This defendant does initially have a 2022 FTA. This offense did occur on March the 1st at 2625 Piedmont Road. I believe that's in Marshall's parking lot. The defendant in this case hit the vehicle of Shamika Simmons with a shopping cart that caused damage to her front bumper. When this defendant was approached by a third-party witness, Mr. Corey Baines, he fled the scene to the MARTA station, and when he was apprehended by officers, he did give a false name and date of birth. He gave the name Alexander Miller to Officer M. Gonzalez, and that is not the defendant's legal name. It was verified through fingerprint scanner. Given this defendant's history, we were able to speak to the victim in this case. She stated that her vehicle was damaged with scratches from being hit with that shopping cart. She is on the line. We would ask that the court sound for her when appropriate. Given the nature of the charges alleged, we're going to be requesting $1,000 surety. That's $500 on each count. No further contact with the victim, no alcohol, drugs, or weapons, no further violations of Georgia law. Nothing further.
Is the victim alleged to have any type of relationship with the defendant?
No, she does not know this defendant at all.
Okay, thank you. Ms. Kim, please proceed.
Yes, Your Honor. Mr. Miller is 49 years old. And Your Honor, there was no intention of this shopping cart. Basically, it just rolled down the hill and hit the car. It was an accident. He had no intention of damaging any property whatsoever. The reason that he gets failure to appear is because he is residentially challenged. So we actually asked our social worker services to have a visit there to provide housing resources for him. He does have 3 children, and one of them is a minor. He has a part-time work, and he's gainfully employed at McDonald's. He also has an associate degree from Tennessee. Your Honor, we would like to request for a signature on bond, and yet if Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $1,000 is a little too much for him, $500. He is qualified for public defender's services, so our team will continuously represent him. Thank you.
Okay, Ms. Simmons, I see you on the line. If you'd like to make a statement very briefly, I will hear from you at this time. You would just need to turn on your camera.
Hello?
Yes, you'll need to turn on your camera if you'd like to make a statement. Please raise your right hand.
Can you see me?
I can see you. Please raise
Okay.
your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
I do.
All right, you can put your hand down. I have a very good understanding of what I believe took place, but I'll allow you to make a brief statement onto the record. Please go ahead.
I think you do have a good understanding. I I was there on business. On yesterday, I don't know the individual. I can't say that he hit my car intentionally. If I say that, I would be lying, but it did cause damage with it hitting my car. I have a dent on the side of my vehicle and a scratch towards the front from damages from the shopping cart. And then he, I think it made him so nervous till he ran
Thank you,
after he saw the dent. So I won't stand before you and say that this man knew me and meant, and intentionally meant to do harm to my vehicle. Or me.
All right. Thank you. I appreciate you coming to court to clarify that point. Is there anything further, Ms. Duncan or Ms. Kim, in light of the testimony given by Ms. Simmons?
No, Your Honor.
All right. At this time, the defendant is going to receive a $1,000 split bond. It's going to be a $500 SOB through the jail for count 1 and a $500 surety bond for giving false information on count 2 for that total of $1,000 split. Was a stay away requested, Miss Duncan?
No, there was no stay away. This was the Marshall's parking lot.
Okay, so I don't know that that's appropriate for him. We don't need to add that then. Additionally, he's to have no drugs, alcohol, or weapons as a condition. Anything further?
Nothing further, Your Honor.
All right, that concludes your case, sir. Best of luck to you. All right, who do we have next?
Position 12, Mr. Sarti.
All right, Mr. Sarti, your case is 23 CR 001198D. In this case, you're charged with criminal trespass with the offense date of March the 2nd. Do you understand, right?
Yes, Your Honor.
All right, thank you. This is his first arrest, so we'll go right to you, Ms. Duncan. Is the offense date correct? This took place today?
That's what we have, Your Honor.
Okay. Well, I'm pleased to see that he got before me so quickly. All right, Ms. Duncan, please proceed.
Yes, this incident did occur today, and the victim in this case is the defendant's wife. Her name is Priyanka Sarithia. I apologize if I mispronounced your name. That's Priyanka, last name Sarathi. In this incident, Your Honor, the defendant is alleged to have taken the victim's cell phone out of her hand after an argument and threw it at the wall, causing a hole in the wall that officers were able to observe with their body-worn camera that was the size of a cell phone. We were able to speak with the victim in this case this morning, and she indicated that they are married and they do share one child. She did state to us that she was in fear of this defendant and what he might do once he is released. She said that this is not the first time that he has been violent towards her, but this is the first time that the police have been involved. And she stated that he's very aggressive and she doesn't want any contact with him and she wants him to stay away from the residence. She's okay with a one-time escort to retrieve his belongings. And to that end, we do have concern about the risk of reoffense, given the victim's statements about the state of the relationship. And we do have some concern about possible intimidation, given that, there is violence and aggression in this relationship, as told to us by the witness. For those reasons, we are requesting $1,000 surety, no further contact with the victim in this case, a third-party child transfer, a stay away from the incident location, which is 425 Chapel St. Leon Court. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. I do believe the victim is on the line, and I would ask for Your Honor to sound for her when appropriate.
Yes, I see, Ms. Priyanka. Would you like to make a statement, ma'am? You don't have to, but if you wish to, I'll just need you to raise your right hand so I can place you under oath. All right, do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, please proceed with what you'd like to tell me. Again, what I am most concerned with is whether you have fear of the defendant and whether you'd like to have contact. So please proceed.
Yeah, yeah, I prefer no contact until we resolve this matter. We have a child, and we also have our family in town helping us resolve this issue.
All right. So you would like to have no contact with him. I
Yeah.
appreciate. Anything else you'd like to tell me?
Yeah, I'm also trying to understand the process of obtaining a surety bond and how soon would the defendant be released.
Well, the best person for you to speak to regarding that would be his attorney. So you intend to bond him out, ma'am?
Yes, and his uncle will be helping him out. Yes.
Okay. Okay. All right. Thank you. I appreciate that. So even though you're going to bond him out, you just don't want him to be in contact with you.
Yes.
Okay. All right. Are you afraid of the defendant?
Yes, ma'am.
All right. You understand that you might have to have limited contact if you intend to come and bond him out. Do you understand that?
Yes.
And there's no one else that will be able to bond him out, is what you're telling me?
No, his uncle can bond him out.
Okay, if I
Yes.
order no contact, it's really not the best thing. I'm gonna listen to his attorney, of course. But if the court decides that you shouldn't have any contact with him, the best person to bond him out would be his uncle and not you.
Sure.
You
Okay,
understand that?
sure. Yes, ma'am. Yeah, I do.
Okay, we're gonna listen to his attorney and make that determination. All right? All right. Ms. Kim, please proceed.
Yes, Mr. Sarati is 40 years old, and he came to Georgia on 2005. So he's been here for about 18 years. And Your Honor, he has been married ever since 2010. They do have one child who is 3 years old, and they also work for same company called ENY, Ernest and Young. Your Honor, my client is a solution architect. He has been there for about 4 years, and my representation will end at the end of this bond hearing. So he will have to hire a private attorney. And Your Honor, my client he denies the allegation, and he was hoping to have a no further violent contact, and yet he respects her wishes, and we would like to honor that no further contact and stay away. And we just want to make sure that there's a third-party transfer for the children. And also he has to work at the same company. So if it is for the company, I mean, I think there's got to be a little bit of room to work together. And Your Honor, we would like to request for a signature on bond if it's possible. If Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $1,000 good bond. Thank you.
Ms. Kim, clarify that for me. They work together?
Yes, they don't work in the same office, but they work for the same company, Your Honor. So there's a little bit of possibility they may have to run into each other, even though they try to avoid.
Do they regularly work on, you said they work for the same company, but not necessarily in the same office?
Correct.
Okay.
They used to work at the same office, but not anymore.
Okay. All right.
Your Honor, yeah, we work for the same company, but not the same client. So yeah, there are some common meetings we have.
All right, but are they via Zoom? Are you able to have space away from him if necessary?
Yes, ma'am. Yes.
All right. At this time, defendant will receive a $5,000 signature bond through the jail. He's to have no contact whatsoever with the alleged victim and stay away from the incident location. He can return one time with law enforcement to get any items. He can have limited contact with her for work purposes only, and only if that cannot be avoided by any other means. Additionally, he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Third-party transfer for child
Oh,
visitation, Your Honor,
yes.
please.
He can arrange to see his children by coordinating with a third party. That third party can make contact with the alleged victim, but he's not to make any direct contact with her other than for work or business purposes. All right.
Judge, I have one question, if it's okay.
Be very
I
careful
will
asking me a
call
question.
you,
but-
and you can call me, please. You have a right to remain silent. You can call me. I'll be happy to explain to you.
Is it about the bond? Is that your only question?
No, yeah, I mean, I'm gonna keep quiet.
Okay, good. I was making sure. All right, take care. Best of luck to you, sir. That concludes your case. All right, who do we have next?
Thank you. Position 13 through 15, Mr.
Okay.
Stitchcomb.
All right, Mrs. Stitchcomb, you have several cases before me today. In each case, you're charged with theft by shoplifting. The first case is 23 CR 00119 The next case is 23 CR 00119 And the final case, 23 CR 00119 These cases took place on November the 30th, January the 5th, and January the 7th. Do you understand your rights as it pertains to each one of those cases, Mr. Stinchcomb?
Yes, ma'am.
All right, Mr. Howard, can I please have the history?
12 total. He got an open case in Superior Court. Possession of a firearm by a convicted felon or felony first offender, and possession of marijuana with intent. It's 22 CP 209-413. I was looking to see if he had any theft history. He got obstruction and fleeing an officer from 2011. He got a robbery conviction, and that was from 2008. And burglary, first offender from 2007. All right.
Okay, that's sufficient, I believe. Ms. Duncan, if there are other highlights you need to make us aware, please do so, but otherwise, please proceed.
On the first instance, in case ending in 1190J that occurred on November 30th, 2022, the defendant did take alcoholic beverages, namely beer, from the racetrack gas station located at 7845 Sonoya Road in Fairburn. He was seen on surveillance camera taking those and passing all points of sale without paying for them. In the next case that occurred on January 5th, 2023, ending in 1193J, the defendant was seen on video taking alcoholic beverages, namely beer, from the racetrack gas station located at 7845 Sonoya Road in Fairburn. He took those items without paying for them and passing all points of sale. And finally, in the third case that did occur on January 7th, 2023, the defendant did take alcoholic beverages, namely beer, from a BP gas station located at 7860 Sonoya Road in Fairburn. At this time, officers viewed the surveillance footage of the defendant taking those items and passing off points of sale and realized that this was the same defendant in the previous two cases listed on the record. At that time, they took out those warrants. Given that this is a repeated offense in that area, the state does have concern about the risk of reoffense, and given this defendant's history, we're going to be requesting a $3,000 total surety. That's 1,000 surety per count per case. Stay away from those incident locations as named on the record. No alcohol, drugs, and weapons, and no further violations of Georgia law.
All right, and to clarify, he took beer from each of those locations?
Yes, 2 24 packs of 2 different kinds of beer, I believe,
Okay.
from those locations.
All right, Ms. Kim?
Yes, Mr. Stinchcomb is 34 years old, and Your Honor, he is gainfully employed. He works at it's a union job at World Georgia Congress Center, and he really likes that job. He wants to keep his job. He completed GED, and he does not want to lose his job. So he would like to request for a signature on bond so he can get out and be responsible and, you know, resolve all these issues. He does not have any other issues, but he was from Georgia. He's been here for 34 years. He resides with his mother, and he's a full-time caregiver as well to his mother who has dementia. So it's very important for him to get out to take care of her as well. We would like to request for a signature on bond. Thanks, Your Honor.
All right. Ms. Duncan, what was the alleged value of the beer?
Okay, let me go through that for you.
If you have it.
On the case from November 30th, the 2 packs of 24 Michelob beer were valued at $35 each. The next one that took place on January 5th, the defendant took one 12-pack of Bud Light beer valued at $14 and two 12-packs of Heineken valued at $19.02 each. And on the third instance that did occur on January 7th, 2023, the defendant did take two 12-packs of Bud Light beer valued at $15 each and one 12-pack of Heineken beer valued at $19.
All right. For position number 13, defendant's gonna get a $2,000 SOB through the jail. He must stay away from the racetrack gas station in Fairburn. For position 14, defendant's gonna receive $100 surety bond with the same conditions, stay away from that racetrack gas station. On position 15, defendant is gonna receive a $50 cash only bond, and he is to stay away from that beer, stay away from that BP. Stay away from the BP station, and have no alcohol, drugs, or weapons. All right, that concludes his case. Is there anything further from the state or the defense?
And there's the no alcohol, drugs, and weapons a condition for all of the bonds as well, yeah?
It is.
Absolutely.
I think that's clear here when I said stay away from the beer. All right, best of luck to you, sir. That concludes your case. All right, who do we have next?
Position number 16, Worthy.
All right, Mr. Worthy, your case is 23 CR 001197E. You're charged with stalking and loitering and prowling with the offense date of February the 23rd. Do you understand your rights?
I don't understand my charges, but I understand.
Well, not your charges, but do you understand your rights?
Not the charge, but yes, I understand the right.
All right. I'm sure they're going to explain the charges to us just now. Mr. Howard, can I have the history, please? If you're speaking, you're muted and we can't hear you.
Yeah, 16 total. Last was back in December, FTA for shoplifting out of Gwinnett. August probation, May trespass. He got an open trespass, loitering and prowling, 22 CR 008522E. Open trespass out of the cab, well, two of them out of the cab county. 2017, what we got here? We got a simple battery and a CWAC charge conviction out of Carroll County. I think that was it as far as the violence. 2011 simple battery family violence, that was dismissed. He had a PI charge from 2013. 2014 possession of tools for the commission of a crime that was not presented to a grand jury. 2015 trespass.
Okay, I think I've got it. Thank you. Ms. Duncan?
Yes, Your Honor, this incident occurred this incident ended at the Milton Package Store located at 13093-1010 Highway 9 in Milton. We have some concern about the risk of reoffense. In this case, it's indicated from the victim in this case that she had gone out of town for a few days, and that she does not know the defendant at all. And while she was out of town, she was checking her Ring camera because she was getting notifications. And she said that the defendant was on her Ring camera outside of her front door looking around, lurking. And then she said a few days later, after she had gotten back home, she was at the gym and she saw the defendant whom she did not know, and he nodded at her. And she said she recognized him from the Ring footage. And at that point, she left the gym and went to the dollar store. And when she went to the dollar store, she again saw the defendant. At this point, she was afraid to go back to her car. So instead of doing so, she went to a liquor store, which is the Milton Package Store that address that I put on the record, and was able to get help from the clerks inside of the store. She said that this this incident has frightened her to the point where she's been sleeping with the lights on, and she's planning on moving because she does not know this defendant at all and does not understand why this is happening. Given that, Your Honor, and this defendant's history, we're going to be requesting a $3,000 total surety, $2,000 on the stalking, and $1,000 on the loitering and prowling. No further contact with the victim in this case, and I'm sorry I did not state her name. Her name is Veronica Webb, common spelling for both. And we're going to ask for no alcohol, drugs, and weapons, and no further violations of Georgia law.
Good
All right.
afternoon.
Well, I'm going to sound first Ms. McLeod from Ms. Webb. I don't see her here, but just to make sure. Ms. Webb, if you're present and wish to make a statement, this is your opportunity to do so. Oh, okay, there's Ms. Webb. Ms. Webb, do you wish to make a statement?
No,
Wait.
everything she
Stop,
said.
stop. Before you
Okay.
say anything else, if you wish to make a statement, I have to place you under oath.
Oh,
Would you like
yes.
to speak? Okay.
Yes,
Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
yes.
All right, you can put your hand down. What would you like to tell the court at this time?
Okay, everything she said is correct. Like I said, I've never seen this man, but for him to keep popping up everywhere I go is really frightening. I have no clue what his intentions are.
All right. Thank you, Ms. Webb. I appreciate you coming to court and making that statement. Ms. McLeod, please proceed.
Your Honor, my client is 36 years old. He is currently employed. He tells me that he works as a handyman for Ace Hardware. He tells me also that he does not know Ms. Webb, never seen her before in his life. So the first time he encountered her was in the dollar store. And he may have nodded his head in her direction, but that was just a gesture of politeness. He denies that he's been stalking her. And I will point out, Your Honor, that the warrant did not say that she positively identified him. She said she had something on her ring camera, which she showed to the officers, and they thought it might have looked like him. There's no positive identification made on my client. And he absolutely denies stalking her. He has no history of stalking at all. And he does not know her. Nobody knows where. Perhaps they just live near each other and keep running into each other. Well, at least he doesn't recall seeing her before the incident in the dollar store. But she seems to think that he's following her around for some reason. But my client doesn't have any history like that, Your Honor. I would ask the court to give him a signature bond because this allegation that, of stalking, it's just unfounded. This man is locked up but just because somebody is uncomfortable that she sees some black man walking around in the store and he looks in her direction. Next thing you know, he's behind bars. I think that is insufficient to lock someone up for, Your Honor. I would ask the court for a signature bond for my client so he can get out of jail and get back to his job. He is quite happy not to have any contact with her because, of course, he doesn't really know her, Your Honor.
All right.
Your Honor, I'd just like to state for the record, she positively identified him as the person who was on her ring camera that she had seen previously, and he was wearing the same or similar clothing as he had been wearing at that time. And I'd like to further add for the record that he had been caught by officers in that area on a different occasion for something else in the past. So officers were aware of who he was at the time, and they were able to piece these things together to positively identify this defendant.
All right. Defendant will receive a $3,000 surety bond. He's to have absolutely no contact with Ms. Webb, and he's to stay away. I'm sorry, Ms. Duncan, what was the incident location?
The incident location was the Milton package store. I can give the court her address. I can send her address to.
Yeah, please send her address to Ms. Bridgewater. Don't say it on the record if you don't mind. He's to stay away from where the victim resides and to have no alcohol, drugs, or weapons as a condition. Is there anything further, Ms. McLeod and Ms. Duncan?
Nothing further from the defense, Your Honor.
Nothing further from the state.
All right, thank you all. Best of luck to you both. All right, the only case that I have is Ms. Phillips. Is that a South Annex case?
Yes, Your Honor. Nicole Morgan for Ms. Phillips. She is in South Annex.
All right, courtroom 2. Do we know if South?
Hey, come here. Come on. Not in movie. I need
Okay, sir, your case is over. If you have a problem, please speak with your attorney and please show respect to the deputies there with you in the courtroom. All right. Do we know if the South Annex will be able to join us?
We've been trying to locate them just like yesterday. I guess something wrong with their phones. Technical issues. So we've been trying to locate them, but.
Okay.
Your Honor, if at all possible, we have the victim on the line. Is it possible to proceed and waive her appearance?
Did your client specifically give you the authority, Ms. Mormon?
She did, Your Honor. Your Honor, she did call and say that she wasn't brought to court. So in the event that she wasn't brought over, she did give me authority to waive her presence.
All right, well, you'll need to send that waiver of appearance over to Ms. Holly Bridgewater for our review, but we can go forward.
She hasn't signed anything. She hasn't
You
signed
can-
an actual waiver. She just
Did she
gave
give you-
verbal express permission.
Did she give you express permission to sign that waiver on her behalf?
Yes, Your Honor.
All right, so if you feel that you have sufficient authority, I'll need you to submit that, shortly here after court. I know, Ms. Falk, that you're going to object. However, it is the court's intent and interest in being able to set bonds.
I understand that, Your Honor, but I think we could maybe just give 2 minutes for them to maybe locate the
I was
South
gonna say,
Annex and have them show up.
We're gonna do that. We're gonna do
Okay.
that. I was gonna ask that courtroom too, before you excuse yourself, please give the South Annex another call or do what we can, just like we did yesterday, even if we have to take a very short recess. And if anybody else, Ms. Kim, I know that you had tried to call over to South Annex without success, but if you might help us in maybe reaching out to see if we can get a hold of Ms. Phillips. As the court has decided, we will go for it, but that is not the preferred method. So let's please try to get South Annex on the line. All right. We'll take a very brief recess.
Thank you.
Is she waiting on me? Cool. Judge Williams?
Yes, any luck with attaining the South Annex or Miss Phillips?
So the ladies are no longer at South Annex. They are at ACDC. I've spoken to the captain over there, and she doesn't have the staff to get anybody to present her. I've even had to cancel my 5 o'clock Orca calendar because they can't provide any assistance for us today.
Okay, Ms. Mormon, as an officer of the court, you feel comfortable that you have sufficient authority to move forward and that your client understands that she will be waiving her appearance and me setting a bond here today?
Yes, Your Honor.
All right, we'll go forward with the waived appearance. Thank you both for your efforts. I find it difficult and I'm sad that we're unable to bring her today, but I completely understand. Y'all take care. All right, we're going to begin with the case of Raven Phillips, 23 CR 001189J. Ms. Phillips is charged with criminal trespass and damage to property, as well as battery, with the offense date of March the 1st of 2023. Her attorney has waived her appearance at this time and will enter that waiver with her signature following this hearing. Mr. Howard has informed me that this is her first arrest, so we'll go straight to Ms. Duncan.
Yes, Your Honor, this offense did occur at 8350 Roswell Road, Unit R in Sandy Springs. It is the home of our victim, Anita Butler. That's ANITA. Butler's common spelling. Here, Miss Butler and the defendant were friends. At one point, she indicated that she let her friend who was intoxicated, the defendant, stay over at her house. And at some point, the defendant threw a rock through one of her apartment windows and broke the window. A physical altercation ensued. And at some point, the defendant in this case did pull one of Miss Butler's doors off of the hinges, and during the physical altercation, she physically attacked Miss Butler and pulled her braids out of her head, leaving bald spots, bruising, and swelling as indicated by officers who took video on their body-worn cameras when they made it to the scene. We have some concerns about the risk of reoffense. This defendant is alleged to have been intoxicated during this attack on our victim, and they were friends at some point. We're not sure that they are going to be any more after this. We have had a chance to speak to the victim, and she does not want to continue with prosecution. However, given the damages to her property and to her head, given that she's missing hair and she was attacked when she let the defendant into her home, we're going to be requesting a $3,000 surety on the battery and $500 surety on the criminal trespass for her to have no further contact with the victim in this case and have a stay away from the incident location, as previously stated on the record. Have one-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law.
All right. Ms. Butler, I saw you on the screen. You're not required to make a statement. However, if you wish to do so, this is your opportunity. I would just need you to unmute and turn on your camera.
Yeah, she may be having difficulty. I know she does want to make a statement.
Well, she needs to respond quickly. We'll delay this. Ms. Butler, if you're here, we need you to turn the camera on. We'll give her a few moments at the end. In the meantime, Ms. Mormon, please proceed into your appearance and give me your recommendation as to Ms. Phillips's bond.
Yes, Your Honor. Ms. Phillips is 27 years old. She is employed full-time. She's a paraprofessional at Dunwoody Elementary. She's also a full-time student at a cosmetology school. She's a Georgia resident. She has absolutely no criminal history. She's never been arrested. I don't know that she's ever even had a speeding ticket before. The victim in this case, Ms. Butler and Ms. Phillips, have been friends for a number of years. I've spoken to the victim in this case. Ms. Butler let me know that this is completely out of character. The erratic behavior is completely out of character for Ms. Phillips. They've never had any issues. Ms. Phillips was at the hospital earlier in the day and she was given medication. She was very ill, and Ms. Butler thinks that maybe the mix with the alcohol had some strange effect on her. They will continue to be friends, as they're very close friends. Ms. Butler did request, she does not want to have a no contact order. She does not want to have a stay away from the location order. She just wants no violent contact, Your Honor. And for those reasons, I would ask for a signature bond. And Ms. Butler did text me and say she's having issues turning her camera on or turning the, I know she's at work.
Okay.
I hear you, but I can't turn the camera on. I'm trying.
Okay, you have to be able to turn that on so we can identify you. All right, Ms. Butler, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, Your Honor.
All right, you put your hand down. What would you like to tell the court at this time?
Me and Ms. Phillips have been friends for a great amount of years. I don't feel threatened by her. I know that was completely out of character for her, so I don't need a stay away contact order. And that's pretty much it.
All right, thank you. Based upon the information before me, defendant will receive a $3,500 signature bond through pretrial services per judge. She's to take that one-day anger awareness course. She's to have no further violent contact with the alleged victim, last name Butler, and have no alcohol, drugs, or weapons as a condition. Is there anything further?
No, Your Honor.
Ms. Bridgewater, the breakdown: 500 count one, 3,000 count two. I'm sorry, Ms. Duncan, were you saying something?
No, saying nothing further from the state.
All right, I believe that concludes the entire calendar. Ms. Bridgewater, will you please review it for us? Oh, you're muted, Ms. Bridgewater. No one can hear you.
Okay, sorry about that. One other thing, I needed the breakdown for position number 16. It was a total of a $3,000 good bond. What was the breakdown on that? The stalking and the lottery and the crown.
I hope I remember, Ms. Bridgewater.
Well, I have a total of $3,000, but we did not break it down.
2,000 on count one and 1,000 count two.
Okay. All right, if we're ready, let's go over the calendar. Position number one is reset to the, oh, by the way, the reset date for the SAP calendar again is March the 16th. Position number one is going to the SAP calendar with a total $8,000 good bond. Position two is reset further notice with a total $4,000 SOB through pretrial per judge. Position three, reset further notice with a total $3,000 SOB through the jail. Position four is going to the SAP calendar with a $1,000 good bond. Position five is reset further notice with a total $1,500 SOB through the jail. Position six, going to the SAP calendar with a total $1,500 split bond. Position seven is reset further notice with a $4,000 SOB through pretrial per judge. Position eight, SAP calendar with a total $3,000 good bond. Position nine is reset further notice with a $5,000 SOB through pretrial per judge. Position 10 is going to the SAP calendar with a total $1,000 split bond. Position 11 is reset further notice with a $3,500 total SOB through pretrial per judge. Position 12 is reset further notice with a $5,000 SOB through the jail. Position 13 is reset further notice with a $2,000 SOB through the jail. Position 14, reset to the SAP calendar with a $100 good bond. Position 15, reset to the SAP calendar with a $50 cash only bond. And position number 16 is going to the SAP calendar with a total $3,000 good bond. Are there any questions, comments, or otherwise? Nope. Okay.
All right, we'll be in recess. Everyone take care. I will not see you all on this calendar for some time, so hope to see everyone soon. Take care.
Okay.
All right.
Bye-bye.
Thank you. Have a good day.